I said I'd like to continue from where Anand, in a sense, left off, where what Anand indicated is there a range of changes which are happening in the way the law conceptualizes ideas of autonomy, ideas of freedom, ideas of dignity. So, what in effect we're saying is these changes will impact the way Indian society begins to think about these issues. So, if we were to say that, we take one step back and say, where is the origin point of all these changes? In a sense, Anand alluded to it, Jaina in opening remarks as well alluded to it, which is really the moment of transformation, which is the coming to being of the Indian Constitution. If you go back to the Constituent Assembly debates, what Nehru says then, it's a very famous speech, everybody knows it, the Tryst with Destiny speech, but he makes one particular statement. He says, there comes a moment, but rarely in history, when we step out from the old to the new, when an age ends, and when the soul of a nation long suppressed finds utterance. So, what in effect he is alluding to is the fact that there's a fundamental shift from an old to the new. And the Indian Constitution is really a product of that fundamental shift. So, in that context, I want to put forward before you the proposition that we need to look at the Indian Constitution as a transformative constitution. It's not a constitution which is reproducing the hierarchy and power which you see around us, but it's a constitution which says that society and the state need to fundamentally transform in demand or taking on account the struggles of the past. If you explore the question of why is the Indian Constitution a transformative constitution, and arguably, and I'll put this as a proposition, I think the Sri Lankan Constitution, by contrast, is not a transformative constitution in terms of the thinking of Sri Lankan activists themselves. And the point they'll make is this. The Indian Constitution is a product of a deep, far-ranging independent struggle and a social struggle. Right? And that's very unique to the constitutional framework. And why do we have a certain sense of reverence for the Constitution? We want to put it that way in terms of what Jaina said and what Anand said. I'd say our sense of respect for the Constitution is not for the dull words of the Constitution. It's really for the spirit which animates it, which is really the struggle, which is both an internal struggle and an external struggle. The external struggle, we all know, is the struggle for British independence, against Britain for independence. But the internal struggle is an equally important one, which once again we need to go back to, which is really the struggle for equality within the Indian context. If you go back to the entire question of what the idea which animates the Indian Constitution, in my opinion, is really the idea of equality. And where does the idea of equality emerge from? I think one of the origin points of the idea of equality is really the struggle of the Dalit community for equality from the oppression of the upper caste. And if you look at the statement again, what is the understanding, right? You're saying, Bal Gopal was one of a very well-known human rights activists. He made the point, he was giving a lecture on caste and the law, and he says in India, caste is the law. So really, when you're talking about the freedom or the equality for the Dalit community, it's really from this notion of caste or the notion of the inequalities imposed by caste. You go back to Ambedkar and the Mahad Satyagraha, and when he takes water from that Chadar tank, his point is that, when taking the water, not because it's of exceptional water, not because the fact that we'll get some divine strength by drinking the water was the upper caste are drinking. He says we're resorting to the Satyagraha, not because we believe that the water of this particular tank has any exceptional qualities, but to establish our natural rights as citizens and human beings. And then he makes an allusion to the French Revolution, and he says, just as in 1789, when the oath was taken, very, very similarly, when we're taking water from the tank, what we're asserting is our right to equality under this land, in this land. And we are asserting the fact that we will smash the steel frame of the caste system. So my point is really this, that is the idea which animates the Indian Constitution, which gives it its life. And the transformative constitution idea comes when we say that is what gives strength to the Constitution, but it doesn't stop there. A transformative constitution means that other marginalized groups and communities can take forward this idea of equality in their own struggle, really. And so the point I want to get to is really this. How has the LGBT community, in its struggle, transformed the Constitution, right? What is its contribution? And in a sense, we look at it that way. We look at, obviously, at least three key judgments. One is NAS Foundation. Second would be the NALSA versus Union of India. Third, of course, is Puttaswamy. And fourth will be the case which we will need to discuss, which is Navtej Singh Johar, which obviously we can't talk about. It's not yet there, but it's very important. NAS Foundation will make only one point. A range of points. It contributes to our understanding of privacy, dignity, equality. But the point it makes above that, again, to drawing from Ambedkar is what it introduces is the idea of is constitutional morality, which is broadly put the idea that we have to understand that India is a divided and hierarchical society, and the responsibility of the constitution is to protect unpopular minorities. And that's a responsibility the constitution must take very, very seriously. We can go more into that maybe in the discussion, but I'll stop with that as the contribution of NAS Foundation. But I want to go a little more in detail into of course, NAS Foundation is overruled by Kaushal. And there's a very interesting line in Puttaswamy where Justice Nariman refers to dissenting judgment and calls it the intelligence of a future day. So our hope really is NAS Foundation is the intelligence of a future day. And if you read Puttaswamy closely, that's the sense you get. The judges are clear, they've got it right. NAS has got it right. And that has to be what the future brings forth, as it were. But to get a little more into NALSA, if you look at the NALSA judgment itself, I think we can analyze it in terms of two broad frameworks. It really takes two concepts very seriously. One is the notion of equality, and second, the notion of freedom. If you look at the Indian Constitution, equality, the norm of equality is there in Article 14, Article 15, Article 16, Article 17, and Article 18, right? And NALSA references 14, 15, and 16. And I'll take you through a little bit of this to say what is its contribution in each of these areas, and how we can take these discussions forward, as it were. 14 says equality of all persons before the law. The starting point of NALSA's contribution is when you say person, you obviously mean person. It's not necessarily man or woman alone. It includes all, it's not animals, it's not plants, it's persons. So people who are not male or female, who would be transgender, will come within the framework. That's the starting point. The second point they go to is they ask the question of when you say equality before the laws, why are transgender people denied that equality? And they come to one fundamental conclusion. They say, when transgender people are not recognized before the law, that is the starting point of discrimination. So it's a very vital contribution. You're saying the fact that you have no identity in law is the starting point for why you experience discrimination. And again, where do they get this idea from? If you look at it a little closely, they go back to, they cite the Yogyakarta Principles, and they talk about the principle everyone has a right to recognition everywhere as a person before the law. So they go back to the idea of recognition of the person before the law in a legal sense. Again, you go back and ask the question, what is the idea of recognition before the law? Where does that come from? It's a very vital part of freedom struggles around the world, where if you go back to the Nazi era, what was done to the Jews initially was deprive them of citizenship, right? You deprived of the right to be a person before the law. You deprived of any kind of legal identity. Look at the entire kind of colonialism. What it did, again, is deprive people of any kind of identity as persons before the law. So what NALSA does is takes this idea of a person before the law very, very seriously and says that's the core point of discrimination. Again, you think about it, in countries around the world, that's the vital problem. Countries around the world, the issue is transgender people not entitled to recognition as persons before the law. So in a sense, NALSA is arguing, regardless of gender identity, you should be recognized as a person before the law. But here I want to introduce one caveat, or one additional point, which is to say that if you take the Yogyakarta Principles plus 10, which came out recently, there were once again a very interesting formulation. They say, Principle 31 says, everyone has a right to legal recognition without reference to or requiring assignment or disclosure of sex, gender, sexual orientation, gender identity, gender expression, or sex characteristics. I want to highlight one point of this. The key point they're making is your right to legal recognition is regardless of disclosure of sex or gender. So the point, in effect, they're making is in identity documents, a key part of the discrimination is because you're required to put in the category of gender. So the question they're raising is one level beyond gender identity. They're saying, in identity documents, do we need gender at all? Is that the starting point of the discrimination which transgender people experience? So they're asking us to think a little beyond the existing framework and saying, can we move to a world where gender is not relevant as far as identity documents are concerned? Of course, there's a range of issues around it. Gender is deeply relevant when it comes to affirmative action, provisions, etc. But that's another question, right? For identity documents, do you need gender? That's the question which is being raised as far as the taking forward the debate on Article 14 is concerned. Article 15 is the non-discrimination provision of the Constitution. Basically says no person can be discriminated against on grounds of sex, religion, race, etc., etc. Right? And here again, what is NALSA's contribution? Very, very straightforward, saying the word sex is not just biological sex; it also includes the question of gender identity. So there's a certain aspect in which you need to think of sex in a broader and a deeper sense. The other point it's making, of course, is saying that 15.2 talks about non-discrimination. It's a very, very important provision. Talks about no discrimination in terms of provision of services, in terms of shops, in terms of places of public entertainment, etc. That is a provision that applies not just to the state, but to be private actors itself. So NALSA, by getting in gender identity within that framework, says, for example, if a shopkeeper discriminates on the grounds of gender identity, that once again becomes actionable under the NALSA framework. So you're broadening the idea of equality, not just at a vertical level, but also at a horizontal level. That, very, very broadly and simply put, is the contribution of NALSA to the idea of non-discrimination. Sex includes gender identity, and there's a horizontal discrimination which you take very seriously. Then the next aspect I want to highlight is when we think of equality, often we think of equality in formal terms. Treat like, and the unlike you treat differently, right? And NALSA's important contribution here is to make the point that we need to think of equality also in terms of groups. And what we need to understand, if a group has been subject to a history of marginalization and violence over a period of time, then there might need to be, might need to make affirmative action provisions to get that group up to the level of equality. Sometimes you need to take affirmative action provision to ensure that an unequal group can get up to the level of equality, as it were. Meaning to say, this is the transformative aspect of the Constitution. It's not okay to just say treat like alike, which case the world will never change. But you have to take positive, affirmative measures to ensure that a group historically subordinated is able to compete on equal terms, or is able to fulfill the promise of the preamble, which is equality opportunity. Equality opportunity can only be fulfilled if a group which is historically subordinated is lifted up, as it were. And so it's a very important innovation where they say the notion of backward class, for which reservation and affirmative action provisions can be made, should include transgender people. And that's, again, NALSA's contribution to the understanding of equality, which is take it a little beyond, just the notion of formal equality itself. The last equality provision in the Constitution, which is not referenced by NALSA, but I'll refer to it, is Article 17. Article 17 is the prohibition of untouchability, which considers the practice of untouchability in any form an offense. That's what Article 17 says. Your point might be, what does Article 17 have to do with the transgender community? On the face of it, nothing. And perhaps rightly the judges have not referred Article 17 in the course of their the judgment. But then you see the opening paragraph of NALSA. I'll read out to you the opening paragraph of NALSA. Justice Radhakrishnan says, society often ridicules and abuses the transgender community, and in public places like railway stations, bus stands, schools, workplaces, malls, theaters, hospitals, they are sidelined and treated as untouchables, forgetting the fact that the moral failure lies in the society's unwillingness to contain or embrace different gender identities and expressions, a mindset which we have to change. So the word Justice Radhakrishnan uses to try and understand the situation of the transgender community is the word, what he says, untouchables. And if you go to in Karnataka, the Dwaraknath Commission, Backward Classes Commission, came up with their finding. The finding that the transgender community comes in the framework of the backward class. Again, you read their understanding, they make a similar point. They say, if their demands, the violations of the human rights are shared, a shocking picture will emerge. It will be noticed that they even treated as untouchables. They're not allowed to use public places, not appointed for jobs, not given loans, etc. While we understand the pain and agony, we're forced to consider the measures sympathetically. So again, the understanding of untouchability and the analogy to the entire question of the transgender community is the point which is being made explicitly by the judgment and by the Dwaraknath Commission. So the question then is there a need? If you see the Article 17 evolution, Article 17 leads up to the SAST Atrocities Act, right? And the Atrocities Act, in a sense, the key point is really this. You're criminalizing certain practices against the scheduled castes and the scheduled tribes, which have functioned from time immemorial in the Indian context. The practices could be tonsuring of heads, the practices could be forcing people, Dalits, to eat inedible substances, could be shaving of mustaches, could be a range of dignity offenses, sexual offenses against the Dalit body. So the question really is, if that is the case in terms of the Atrocities Act, is there a similar call for a legislation which captures the range of indignities and violations suffered by the transgender community? Again, the question is not a superficial question. The question has to be based on a anthropology of the kind of offenses to which the transgender community is subjected to. If you look at the Atrocities Act, the specificity of it is some of those offenses you can capture within the Indian Penal Code, fair enough. But there's a way in which the offenses happen, which is so specific to this particular caste practice that it needs to be captured in a separate legislation, as it were. And our friends who were discussing the transgender bill in Bangalore, including Rumi and Sunil and G, came up with, I thought, a very, very powerful listing, of the kind of offenses to which the transgender community is subjected to. I'm just going to read it out to you, also as a sense of how far we have come, as also how far one needs to go. Because if this is what is happening in an everyday basis, in villages and places around Karnataka, and I'm sure around the country, then there's really a long way to go in terms of the journey, in terms of the practices of, we want to call it untouchability or violence or brutality against the transgender community. I'll just read it out to you. The kinds of offenses to which the transgender community are subject include sexual assault without penetration, without objects, forced group sex without consent, violation of types of non-consensual forced sex enacted during sex work, forcible cutting of hair for hijras and the reverse for trans men, forcibly making a person dress in a certain attire, lynching, beating, harassing, burning, tying up, stripping, and traumatizing to ensure gender conformism, forcibly marrying off a trans person under duress, forcibly performing corrective surgery in intersex infants or persons, house arrests or restricting mobility of trans persons in order to make them conform, verbal and physical abuse of all kinds, doing funeral rites of a trans person in the gender or attire that the person rejected during his or their entire life. So you get a sense of the other dimension of equality which the Constitution envisages vis-a-vis the practice of untouchability, which should be envisaged via legislation as far as the transgender community is concerned. That's the equality part of the analysis of NALSA. The other part of the analysis of NALSA is the entire notion of what we call the rights of freedom. And here they reference two freedoms. One is the right of freedom of speech and expression, and the other right to life and personal liberty under Article 19.1a and Article 21. If you look at 19.1a, right to freedom of speech and expression, everybody knows what the idea of speech and expression is, and if you look at the interpretation of the Supreme Court, it's often gone down the line of looking at, the right to freedom of the press, the right to artistic expression, a range of ways in which freedom of expression is absolutely important in the history of this country. But NALSA's contribution is really taking 19.1a in a different direction. What NALSA says is 19.1a, which is freedom of speech and expression, states that all citizens shall have the right to freedom of speech and expression, which includes one's right to expression of one's self-identified gender. Self-identified gender can be expressed through dress, words, action, or behavior, or any other form. No restriction can be placed on one's personal appearance or choice of dressing, subject to the restrictions contained in Article 2 of the Constitution. So when they look at gender expression as a part of freedom of speech and expression, you're communicating another depth, another level to the idea of expression. Here what you're getting forward is the idea of expression is intimate expression. There are forms of expression which are so close, so intimate to a person, so much a part of a person's self and identity, and they're so integral to the person's ability to be who they are, that they need to be protected under the idea of the right to expression itself. And of course, the right of expression, this form of expression is closely linked to the notion of dignity. And as Anand indicated, we can't see 19.1a outside the framework of 21. Expression is linked to dignity as well. I'll finish in 5 minutes. And the point I want to make on opinion and expression is in terms of how we think of expression of intimate expression. On 21, which talks about the right to protection of life and no person will be deprived of life or personal liberty except by procedure established by law, right? What do you mean by life? NALSA's understanding is that life is not bare animal life. Life has to mean a life which can be lived with dignity. When you're talking about dignity, dignity is very closely linked to your right to make intimate choices about your own life. You cannot live a dignified life if the state criminalizes who you are. So gender expression and gender identity, since it's so integral to who a person is, it forms an integral part of dignity. You look at the question of liberty again under Article 21. Liberty is the right, once again linked to the right of expression, and the right to intimate expression comes in under 21 as well. So your right to make choices about who you are, about the person you are, is very much a part of the 21 framework. And the gender identity comes within this framework. As they put it, recognition of one's gender identity lies at the heart of the fundamental right to dignity. Gender, as already indicated, constitutes the core of one's sense of being, as well as an integral part of a person's identity. Legal recognition of gender identity is therefore part of the right to dignity and freedom guaranteed under our Constitution. I'll conclude with just making this point, that I think we can analyze NALSA as having these two strands. One strand is the equality strand of the jurisprudence. The other strand is the freedom part of the jurisprudence. And really, the way one can see it is these two strands of a DNA, and the two are very integrally linked. And how we take forward the vision of imagination of NALSA really depends on how we understand equality in all its dimensions. We understand equality not just as formal equality, we understand equality as substantive equality, both in terms of criminalizing practices which dignity offenses as far as the transgender community is concerned, as well as affirmative action provisions as far as the transgender community is concerned. And we have to see this strand along with the freedom strand, that regardless of the equality part, the point of right to express one's gender is so integral of freedom because so much a part of who you are. And if so much a part of who you are, that the state cannot criminalize, that the state cannot allow you not to express. It is the duty of the state to protect your right to express your gender and to take forward your identity, or your gender identity, as it were. So I'll end with that, just to make the point that the point I really want to end with is to say that when we say the Indian Constitution is a transformative constitution, it's really this idea that the Constitution as a text is a product of a certain kind of struggle, and we are hoping that the struggle of the transgender community, the struggle of the LGBT community, in a sense, contributes to a wider imagination of both freedom and equality is concerned. So in a sense, that's echoing what Anand is saying, where really, end of the day, we're not talking about an interest of one community alone. We're talking about something which is integral to the definition and understanding what freedom and equality itself is. And we hope that the coming discussion or the coming judgment, as far as the Navtej Singh Johar is concerned, will take forward this imagination of both freedom and equality in this sense. Thank you.